Am I allowed to record conversations at work? Have we ever wanted to hit record during a meeting at work? Maybe it was a tense talk with a supervisor. Maybe it was a conversation about safety concerns. Or maybe we just wanted proof of what was really said. The big question is, are we legally allowed to record conversations at work? The answer is not simple. Under federal law, recording is sometimes legal if just one person in the conversation consents. But many states go further, requiring everyone in the conversation to agree. Breaking the wrong law could mean more than losing a job. It could mean fines or even criminal charges. In this video, we'll explain the rules clearly. We'll cover what federal law says, how state laws differ, real cases where recordings helped or hurt workers, how company policies fit in, and the smart steps to protect ourselves. Let's dive in, because recording at work is a legal minefield. 1. Federal law, the one-party consent rule. The starting point is federal law. The Wiretap Act of 1968, updated by the Electronic Communications Privacy Act, ECPA, of 1986, makes it a crime to intercept private communications without consent. But there's a big exception, the one-party consent rule. Under federal law, if one person in a conversation agrees to the recording, it's legal. That means if we are part of the conversation, we can record it, even if the other person has no idea. Example: we're in a performance review with our manager. We decide to press record on our phone without telling them. Federal law alone would not prohibit that recording because we are a consenting party. But federal law sets only the floor. States are free to set stricter standards, and many do. That's where workers must be careful. 2. State laws. One-party versus two-party consent. Here's where things get tricky. Most states, about 39, follow the one-party consent rule, just like federal law. But 11 states require all-party consent. In these states, every person in the conversation must agree before it can be legally recorded. One-party states include New York, Texas, Ohio, and Michigan. Workers there can record conversations they are part of without telling others. All-party consent states include California, Florida, Illinois, Maryland, Massachusetts, Montana, Nevada, New Hampshire, Pennsylvania, Washington, Connecticut, in many contexts. In these states, secretly recording a work conversation without the other person's knowledge is illegal. Penalties can include fines, damages in civil lawsuits, or even criminal charges. Example: a worker in California secretly records HR while complaining about harassment. Even though the goal was to prove mistreatment, the recording itself is unlawful and might not even be usable in court. Worse, the worker could face liability. 3. Employer policies. Legal versus workplace rules. Even if recording is legal in our state, company policy adds another layer. Many employers have rules banning unauthorized recordings. They argue recordings threaten privacy, create a chilling effect, and risk leaking confidential information. Breaking such a policy isn't usually a crime, but it can get us fired. Courts have generally upheld an employer's right to discipline workers for violating no recording rules as long as those rules don't infringe on protected rights, like union activity. Example: a hospital bans recording due to patient privacy under HIPAA. A nurse secretly records a supervisor yelling at staff. Even in a one-party state, the nurse may face termination for violating policy, though the recording might still serve as evidence of hostile conditions. So, legality and job security are not always the same. Workers must weigh both. 4. Real-world examples. Looking at actual cases helps make this real. Discrimination case in a one-party state. A worker secretly records a manager making racist remarks. The recording becomes powerful evidence in a lawsuit and leads to a settlement. Case in a two-party state. An employee records without consent. The court throws out the evidence, and the worker faces counterclaims for illegal wiretapping. Union activity. The National Labor Relations Board has ruled that blanket bans on recording can sometimes interfere with workers' rights to organize. But this depends on context and hasn't eliminated employer policies altogether. Whistleblower protections. In some industries, like finance or food safety, whistleblowers may be shielded when making recordings to expose illegal conduct. Still, courts differ, and state law remains critical. The lesson: recordings can be decisive, but only if done legally. Otherwise, they may hurt more than help. 5. Common questions. Workers ask, "Can I record my boss to protect myself?" It depends on state law. In one-party states, yes, usually. In all-party states, not without consent. What if the recording proves harassment or discrimination? Courts may admit it if legally obtained. If illegally obtained, it could be excluded and create legal risk for us. Can my employer ban recordings entirely? Yes, through workplace policy. Violating that policy may not be a crime, but can still result in discipline or firing. What about Zoom or Teams meetings? The same rules apply. If state law requires consent, everyone must agree. Many platforms have built-in recording notices to comply with laws. What if I record to report a crime? In some cases, whistleblower laws or law enforcement cooperation may override restrictions, but we should never assume. Legal advice is key here. 6. Best practices for workers. So how do we protect ourselves while staying safe legally? Step 1. Check state law. If you live in California, Florida, or another all-party state, secret recording is risky. Step 2. Review company policy. Know what's allowed and what's banned in your workplace. Step 3. Consider alternatives. Instead of recording, keep detailed written notes after meetings, send confirmation emails, per our conversation today, or ask a trusted co-worker to be present. Step 4. If harassment or illegal conduct is serious, seek advice. Employment lawyers can guide whether recording helps or hurts in your state. Step 5. Protect confidentiality. Never record attorney-client conversations, medical discussions, or sensitive data unless clearly legal. Example: a worker in Texas, a one-party state, wants to protect herself during a retaliation dispute. Instead of secretly recording, she documents every meeting with follow-up emails. Those written records later serve as strong evidence without any legal risk. The best practice is simple. Don't press record until you're 100% sure it's legal and smart. 7. The bigger picture. Why is this issue so complicated? Because the law tries to balance two competing rights: privacy and accountability. Employers want to protect confidentiality and avoid constant surveillance. Workers want to defend themselves against abuse, discrimination, or retaliation. Federal law leans toward one-party consent, but states like California or Massachusetts prioritize privacy with all-party rules. Technology makes things harder. Smartphones, Zoom calls, and AI transcription blur the line between personal and professional space. Lawmakers continue to debate updates. Until then, workers must navigate a patchwork of federal, state, and workplace rules. Awareness is our best defense. So, are we allowed to record conversations at work? The answer is, sometimes. Federal law says one-party consent is enough, but 11 states require everyone's permission. On top of that, many employers ban recordings through workplace policies. That means hitting record could be legal, illegal, or simply a fast track to getting fired, depending on where we live and who we work for. The safest approach is to know both the law and company rules, and to use alternatives like written notes when possible. If the issue is serious, like harassment or retaliation, seek legal advice before pressing record. If this helped clarify your rights, share it with coworkers. Knowledge protects us, and together we can stay safe, smart, and legal at work.